County and Washoe County come in and speak to us about what their role is in combating domestic violence and sexual assault in the community and how they respond. And so we're kind of moving to the next step now of once law enforcement has compiled what they need to compile and they move on to the prosecution step possibly to the DA's office. So I have invited two lovely DAs to come in today and speak about their role in combating domestic violence and sexual assault. So we have Kay Lyon from Washoe County,
Hi.
so Nevada, and then Maria Leftwich from Placer County, so that's California. So they're going to talk about the differences too when it comes to laws and things like that. So my first question is, tell us your title and how long you've been working in the criminal justice system.
Okay, I'll start. My title is Deputy District Attorney, and I've been working in the criminal justice system in Washoe County, Nevada, 18 years. I was hired in March of 2000. And prior to that, I worked as a prosecutor in Bannock County, Idaho for 6 years. So I've been, I think, 24 years in the criminal justice system.
Nice.
And my title is also Deputy District Attorney, and I've been in the criminal justice system since 1997. I've been with Placer County for the last 3 years. Before that, I was with Sonoma County. I was also a sheriff for a little bit, and I did some actual public defender work too.
Oh, nice. Great.
Didn't know you were here.
Great. Okay, so we'll start off with giving like a little background of what does the process look like of becoming a district attorney in your state, and is it an elected or an appointed position?
Okay, in Nevada, the elected official is called the district attorney for the county, and that's an elected position, and it's currently held by Chris Hicks. He just is going to be running unopposed for a second term. And he hires what are called the deputy district attorneys, which would be me, who basically act in court as a representative of the district attorney who represents the citizens of Washoe County. And all our pleadings and captions and motions are state of Nevada versus the defendant. And so it's a public entity acting on behalf of the citizens of the county, prosecuting criminal offenders. And we are hired through an interview process. We have to have a college degree and a law degree. And we are what's called at-will employees, which means if Chris doesn't like us for some reason, he can just get rid of us. So we have to make sure we do a good job and do the right thing on behalf of the people. And our job isn't just to get convictions, it's to see that the right thing is done in certain cases, or basically in all cases.
And that's pretty much the exact same in California. The only difference is that we are not at will. They can still fire us, but they have to have a reason to do so. But it's an elected official and all the
Okay, same process. Okay. Joe?
Do you prosecute all types of cases, or you specialize in a particular area, or?
I currently do mostly, there's two of us I'm in the Tahoe City office, so I currently am doing all of the DUIs, felony or misdemeanor, and any other cases that my partner doesn't do felony-wise, but we both just do across the board. So I'll do domestic violence and DUIs and batteries, and
I do pretty much everything except homicides.
And how many people are in your office?
There's 36 criminal deputies.
Wow. Okay. So we had law enforcement come in yesterday, not last week, was what the question says, and they told us how they, when they respond, how they're looking to put a case together and work on that. Can you pick up where they left off and share what happens when the case comes to your desk and what your role is?
Go ahead.
I'll get the case, and it will be the police report and any supporting documents, and I review it, and I see whether or not there's enough there for me to prove beyond a reasonable doubt at a jury trial any charges. And if I can't prove it beyond a reasonable doubt, then I file. If I can't prove it beyond a reasonable doubt, I'll either send it back for further investigation if I think that they can find something to make it stronger, or if I have pretty much everything I'm going to get and I can't prove it, then I need to decline it.
And that's basically the same. Prosecutors have an ethical obligation to not pursue charges they don't believe are based in probable cause. And probable cause is a lot lower than beyond a reasonable doubt, but realistically, if you get a case in that's barely probable cause, or you just have probable cause, which means the guy probably did it, you're gonna have huge problems. So that's probably not a case that we would end up filing. So we have to look at the case in the beginning. A lot of times we send cases back for further investigation, gather other witness statements, review jail calls, do phone searches, stuff like that, to make sure we have as much evidence as possible to make a fair assessment of the merits of the case, and then go forward with the charges that we think are appropriate.
Thanks. Can you explain what reasonable doubt means?
Reasonable doubt, believe it or not, is defined by statute in Nevada. It has words like feeling an abiding conviction of the truth of the charge. And if you guys can figure that out, then that's pretty
Could you
impressive.
start with feeling?
Feeling an abiding conviction to the proof of the charge. So it's what the jury kind of gets, you know, like your gut. When you hear something,
Yeah.
it either has a ring of truth or you're like, come on.
Or it triggers something.
Yeah, but it's defined by statute, and the lawyers that, you can't argue about what it means. The most you can do to a jury is give them the instruction and say, here's what Nevada law says reasonable doubt is. You cannot argue as to the meaning of any words. It's improper. And so you just give them the definition
Well, I
of the
feel
jury.
this, then I
And
feel
it says it's not beyond all doubt. For a doubt to be real, it must be reasonable. It must be reasonable doubt, you know. And they're told not to speculate, you know, stuff like that. So it's a fairly solid definition. I have no issues with it.
You said feeling of abiding
Conviction.
conviction. Oh, that's very interesting.
I know.
Yeah,
I was
it leaves
wondering
in
how
the
much
minds
the
of the
subjective
jury,
versus-
something about leaving in the minds of the jury an abiding conviction of the truth of the charge. So,
Oh, man.
Yes, that's what it
Yeah.
is in California
Yeah.
too, and it's really fun to say. so.
Yeah.
You
You're
say
like,
truth
huh?
of the church.
Truth of the charge.
Thank you.
Yeah.
Oh my
You're
gosh.
all saying in unison.
Where are you from?
Australia.
Oh, great.
I've been here a long time.
I've been there once.
Yeah.
I love the accent. No, twice. I've been there twice.
So the same thing goes for California, and you just hand them a piece of paper and they have to interpret it.
Right, well, the judge says what it is.
Okay.
And they also can get it written down, but we can't make analogies, we can't say it's like
You can't
filling up your
quantify.
gas
Oh, I
tank.
see, okay.
Yeah.
You know,
And
it's,
the defense counsel, the defense attorney isn't allowed to quantify either. They're not allowed to say, it's 110%, you know, or if you're absolutely positive, because that's not the standard.
Is that kind of a federal interpretation? Is that, if we went to Michigan, do you think we would be the same?
Similar,
definition?
probably, my guess would be similar.
That's amazing language. I mean,
It
it's-
is amazing. Yeah, and it's defined by statute, so if you just search reasonable doubt definition in the NRS, the Nevada Revised Statute.
Okay. So for each state that you guys represent, or county that you represent, what is the difference between the misdemeanor and a felony domestic violence charge?
In Nevada, there's a big difference. We have graduated sanctions for domestic batteries in Nevada. The first one is a misdemeanor, assuming it wasn't by strangulation and assuming there's no substantial bodily harm. The second conviction, assuming those things are true, is still a misdemeanor, but the jail term goes up to 10 days as opposed to a mandatory 2 days with a maximum of 6 months. A third domestic battery in Nevada is a felony with mandatory prison between 1 to 5 years. We just recently passed a law that became enacted in January 1st, 2018, which means if you have a felony domestic conviction, your next domestic battery, no matter how minor it may be, is an automatic felony carrying a 2 to 15 mandatory prison term, which is much similar to the DUI law. Once a felon, always a felon, and now applies to domestic batteries.
And it's a recent change?
Yes, it just came
What
on
precipitated that?
January 1st. Probably the amount of repeat offenders is my guess, because in Nevada, before that law came into effect, we couldn't get a felony on someone unless all their domestics occurred within a 7-year period of each other. So 8 years, he starts over and gets another misdemeanor. So it was a 7-year period where if he's not convicted 3 times, then his next one's just gonna be a misdemeanor. So I think it was just the outcry for making it more reasonable,
Right.
I mean, making it make sense, basically, and having it more consistent with the reality of what happens in battering relationships and the recidivism rate of domestic batterers, as well as a deterrent effect, for one thing. And if we can do that for DUI, why aren't we doing it for domestic battery?
What is the recidivism in Nevada?
Well, I was just telling Maria, I don't know, I can't give you a percentage, but I was just telling her right before we started that I have had in the last couple months 3 repeat batterers come back. And I have to say that I kind of thought they would come back, but I was hoping not so soon. Part of the problem was I had victims recanting either under oath or just recanting in general or not showing up. So I had to give the batterer a certain kind of deal, which meant he got out of jail a lot quicker than I would have liked. But, you know, it's tough. And I think all of them have the same victim. So hopefully I won't have the same issues again, but you never know.
And so for California?
In California, it's quite different. If there's no what's called traumatic injury, and that means any kind of injury, major or minor, internal or external. If you can prove a traumatic injury, then it can be either a felony, which would be a maximum of 4 years, or a misdemeanor, which would be maximum of 1. And we would charge it misdemeanor or felony depending on their history and depending on how bad the injury is. If there's no injury, say it's shoving or pulling hair or something where they don't leave a mark or any injury, then it's a misdemeanor even if it's your 10th. It's always going to be a misdemeanor.
Just, I don't want to dominate, just.
No,
because
no, you go
it's
for
right,
it.
and you have kids.
I prefer to answer questions. I think
Yeah.
Maria does too.
Yeah.
Did they end up going into federal prisons then, or did they stay in county jails then? Is that where it is?
In Nevada,
State
prison
prison.
means prison.
Okay.
A misdemeanor is jail, but in Nevada, prison means you go to a state-run facility by the Nevada Department of Corrections. And I know the law is different in California where you can serve out a prison term in a county jail.
On some offenses.
Yeah.
Yeah.
Can you guys describe the difference between when someone pleads no contest versus guilty?
In California, the no contest plea, the judge takes it as a guilty plea, and it's pretty much the same thing, except for maybe in civil law, they can say, well, I didn't plead guilty if they're sued.
It's basically the same in Nevada. It's considered a guilty plea for conviction purposes, and so the end result is really no different. It just gives the person a chance to say, whoa, you know, I'm kind of throwing myself in the mercy of the court. You know, I don't want to say I did it, but I think they can prove it beyond a reasonable doubt, you know, that sort of thing.
Okay, so you guys did talk about the penalties associated with each charge. How often do offenders actually get the max penalty?
Rarely, unless it's repeat, criminal history's bad, severe injuries to the victim, you know, but it's rare for, unless there's some other circumstance for someone to get a maximum type of sentence.
To get like a 15-year?
Yeah.
Because you said 2
Yeah.
to 15?
Yeah, 2 to 15. In Nevada, you can't serve more than 40% of the maximum, so that would be like a 6 to 15 would be the maximum for that.
Okay.
But that would be, if a person was to sentence to a 6 to 15, there'd have to be severe injuries or severe criminal history or, you know, something of that nature to aggravate it to that level.
Can I ask a question? So, because coming from Australia with that and my own experience of minor road crimes and getting off, and I'm like, huh? It doesn't make sense. It's like, it's absolute in Australia, the little I know. So those maximum penalties, are they then for the maximum crime? Because in my head, I'm like, well, you do the crime, that's the penalty, but then it sounds
There's
like
the range,
flexible.
yes,
So that's
exactly. It's between a 2 to 15, which
Right.
means the very minimum the judge can give is 2, and the judge can't give more than 15 for that particular crime. So there's a range in there.
Which is interesting.
Yeah, there's not just a set, okay, 5 years, which would be a lot easier.
Yeah.
And then so then you're saying, so say the judge gives them 2 years, they only can serve 40% of that 2 years.
They have to do more than 2. 2 to 15 is the range, so they have to set a minimum and a maximum. They can't just say 2 years.
Do they have a minimum
I see.
mandatory?
Yes, 2 years.
2 years is minimum mandatory.
Right.
Oh, I see.
Yeah.
They always just give the range, they don't just.
They give a range. In Idaho was what's called determinate sentencing, which they had a range of, you can get an 8-year, let's say an 8-year determinate sentence, and that was it. That's what you're doing for that crime. Or you can get 3 years determinate plus another 10 indeterminate, which would mean the parole board can have the option of giving you parole after 3 or placing you on supervision and releasing you after 3. But in Idaho, you had that choice. And in Nevada, it drives me crazy because the way they calculate time at the prison, sometimes people get, depending on the category of felonies, and we have category A's, category B's, category C's, category D's, and category E's. So we have a huge range, and their credit for time served gets shrunk, sometimes on the bottom end and the top, depending on the level of category of crime. Category A, you're not going to get the type of benefit that you would on a C or a D or an E. An E is basically mandatory probation. So
And what is an A in terms of?
an A is
severity?
up to life.
And what type of crime generally?
Murder, sex assault on kids, stuff like that. Lewdness.
Knowing that with that flexibility in the system and working in it, do you think that's good or?
Yeah, it gives us some leverage. It gives the prosecutor, I like to have some leverage, saying, well, you're looking at the 15-year max, I'm willing to cap my recommendation at 10. So then that would bring it down to a 4 to 10 instead of a 6 to 15. And hearing a prosecutor say, I think the case deserves 4 to 10 as opposed to a 6 to 15, judges are generally going to, in my experience, trust us to know that we know the value of our case and generally follow negotiations.
And then like the sheriffs last night was saying, sometimes they'll feel that they've given you guys all the tools and then the decision goes the dead opposite.
Yeah. Yep,
And
That
I was like,
happens.
that's interesting.
that does
because
happen.
They've had that frontline experience. I don't know where you guys are on that.
We are nowhere near the front line. We're sitting in an office, looking at paper, and they might say Monday morning quarterback, But we have to evaluate what they did, what they found, what they saw, how they documented it, and sometimes we don't see eye to eye, and that's just the way it is.
Do most of the defendants, are they usually using public defenders, or a lot of them have their own defense attorneys?
Ours probably mostly use public defenders,
Yeah.
but we've got a good share that have private attorneys.
I'd say it's the same, but fair amount of private counsel.
Okay, so for Maria, how often do offenders get the max penalty in California?
It's also very rare, and ours is different. We have what's called a triad. So you have a mitigated term, which would be, for this would be 2 years, for domestic violence with traumatic injury, it would be, it's called a 2, 3, 4, and 2 is mitigated, and they can also get probation. So, this is even assuming they're going to prison. And you've got to really work your way into prison in California. So,
Or beat your way into prison.
yeah, right.
Beat your way into prison.
Right. So you could get probation, even on a felony. But if you actually are going to go to prison, we have probation does report, and they'll say these are the aggravating circumstances, these are the mitigating circumstances, and if there's more aggravating circumstances, then it's likely that they will get the higher end. If there's mitigating, they'll get the lower, and if it's kind of washes out, they'll just get the middle term. So they've got to get the middle term unless there's something mitigating that the court can rely on and say, I'll give you the low term, or something aggravating that they get the high term. So most people get the middle, and it's rare to get the high end unless there's, extreme injury and bad history.
What is, I know what mitigating is, but what is some examples?
An example would be,
Like they have a job, would be one?
yes, or that they don't have a history, or the injury wasn't severe, or they've got maybe a self-defense, or
Okay.
something like that, something to make it less than a normal domestic battery.
Okay.
They were going through a really stressful period of their time, and something like that, something to make it, something to give the judge something to say, well, you're not as bad as most of the people that do this, or this incident's not that bad, as bad as most.
Even saying you're sorry, having a sincere,
Remorse.
sincere articulation of remorse can be a mitigator.
Now, do they have like a point system on that, or?
They need a gong.
Yeah.
Don't believe you. Yeah. Sounds
But
sincere,
and then
sorry.
aggravating is obviously like crazy
Like-
circumstances that they did.
Mm-hmm. They've got a really bad history. She escaped and he went after her and beat
Okay.
her more. It's like
Yeah.
where you look at it and you're like, wow.
Stopped her
dude.
after the fact.
Yeah.
Okay. Yeah.
Yes.
Gotcha.
Yeah.
Children
Tried to get her to
present.
not
Yeah.
testify.
Yeah.
Okay.
Yeah.
The ones that go to trial are all the juries different in terms of their perception, their so you get this whole wide range.
Yeah.
It's, you know,
Yeah. We've had, yeah. And it's, you get to talk to them first before they're picked to be an actual decider of the case. And a lot of times in domestics, the last one I had, it took a really long time to pick a jury because almost everyone raised their hand because they had some sort of connection to domestic violence. Whether they were a victim themselves, they knew someone very close to them who was a victim, they grew up in an abusive home, or someone close to them was incarcerated for it. It was just something that, almost everyone raised their hand.
That's how common it is.
Yeah, it was pretty eye-opening, yeah.
Is there, do you find, like, in terms of the age generational difference, because it's always blown my mind, because I think it wasn't until that many years ago, the early 60s, that there was no rape charge against a husband. So I'm wondering in terms of the age, if you have older jurors who are still living in a culture where it's like the woman's fault that the husband beat the shit out of them or raped him or whatever. I mean, I don't want to just totally generalize, but there's a lot of that sort of,
They're all your mates, right?
yeah. There's people I went to
Your
college with,
contemporaries.
Yeah, it's
Yeah.
interesting because it seems to me that our mores are obviously changing pretty drastically in culture. And how much is a cultural effect?
For me, in my experience with these cases, it's not necessarily a group, but an individual juror. I find that older males, are much more judgmental against younger males who beat up women because they have this "you don't put your hands on a woman" type mentality. They don't want to admit to anybody else, of course not even the rest of the panel, that maybe they think it's okay to put your hands on a woman. So they have, in my mind, a protectionism towards a female no matter what. Especially younger victims, younger female victims. They may see a daughter in that victim, they may see a granddaughter in that victim. Sometimes older women, on the other hand, can be a little more judgmental depending on the age of the victim. If she dressed a certain way, or she sexy texted someone, or how, but it just comes down to a feeling of the individual juror. And what I found is mostly men are very intolerant against other men who commit violence against women. And for the most part, the vast majority of women are equally as intolerant, of course. So. But, there's been not guilties and,
The person who surprises you.
Yeah.
So, yeah.
So you guys talk to every single juror?
Yes, when we're picking them, we do our best. It's called voir dire. It's a fancy Latin term, I think, for to speak the truth. And they're put under oath, and so they have to tell you the truth if you ask them a question. The judge questions them first, just general stuff like, do you know anyone? Do you know these guys? You heard about this case in the newspaper, whatever. And then we get a chance to kind of, you can't ask them, would you find this defendant guilty in a domestic battery? I mean, you can't be specific to the case, but you can get general questions out and kind of get a feeling for each juror. And I look for eye contact and if they're engaged and if they seem to get along with the rest of the panel. And then there's always the odd duck that, if they're chosen for the jury, the rest of the jurors are going to kill you because that person's going to be a weirdo. So you want to get rid of them and, it's just... It's true.
Yeah, no, I mean,
And they might hang the
I think
every time
I
you
think
guys
one of
talk
the
about
best
this, it
one
just
of the
amazes
best
me.
one of the best signs that I have a prosecutor find is when I come into the courtroom, and the jury room is just like an ante room right off the courtroom with they have a private door and everything. So you can hear them when they laugh, and when they're laughing as a group, I'm thinking, oh, they're getting along great, this is really good for me. Because that means they're working as a group, they're gonna be able to make a decision, and everyone's happy, so.
So what happens if a jury is hung? I mean, what does that mean? I've always wanted to know, I guess, what does that mean?
In California, we can retry
Okay.
on the charge, so.
That means, and 12 people did not agree. And in California and I think almost every other state, if not every state, 12 people have to be unanimous. They all have to agree as to the verdict. It just takes one for a what's called hung jury, where they can't decide.
And in Nevada, you can retry?
Yes.
Okay.
But
a
how
lot of
long
time and
sometimes
effort.
does it take
Yeah.
if they can't get one to turn, how long will they go? You know?
It's up to the judge, but usually you want to try and get them a long time. You don't want to have them just deliberating 3 hours and then say, oh, we can't decide.
Right.
You know, so hopefully a substantial period of time. It just depends on the type of trial. If the trial's 6 weeks, and they come back after a day and say we can't decide, the judge is going to send them back and say keep working on it.
To a consensus versus.
Oh yeah,
Yeah, I think so, regardless of whether
Right.
it's a conviction or.
I would much rather have a unanimous verdict than a hung jury.
So if it's another day, it's another day. Make a decision.
They can't decide on what donuts they want to eat.
Yeah, how did they get treated?
Yeah,
Like,
yeah.
they get treated pretty well in there?
Oh yeah.
Yeah.
Once they're deliberating, I mean, they can't, unless they're sequestered, I mean, they have to stay a certain number of hours, but they get fed, and,
Nice.
I don't necessarily think it'd be
They get
super
paid
fun.
too, right? No.
Not
I don't think
much.
so.
Ours do, but not.
Maybe.
Not that much.
A nominal,
Yeah.
nominal thing, yeah.
Your
Yeah.
civil duty.
Can
Yeah.
I ask where, for the California one, I'm in Placer County,
Mhm.
where do we go if we get, is it up here or
If-
down in Orbit?
If you're up here, if you're in Tahoe City or
Mhm.
Kings Beach, you go to Tahoe City.
Okay.
Yeah.
Nice. Tell us
Yeah.
about plea deals and why they occur.
Plea deals have to occur, otherwise nothing would get done. I mean, we don't have enough people in court system and jurors to take everything to trial. So they get, and they're a good thing because they get people on, especially if they're gonna be on probation, then if they violate that probation, we only need to prove it by preponderance of the evidence, which is, and only to a judge, and that is, preponderance is just, he probably did it, or she probably did it. And then we can give them whatever consequences. For example, on a misdemeanor, it would be up to a year. And in domestic violence, it's important because part of probation is going to a 52-week program. Just putting them in jail is not going to make them stop. Hopefully, some counseling and some consequences and having jail hanging over their head would be enough to make them stop. Obviously, it doesn't always, but it gives us kind of leverage on them without having to take it to a trial.
Anything bad?
They're beneficial because, as Maria said, they make the system work and move ahead, and it spares the victim the need to have to testify, the trauma of that. You get an acknowledgement of guilt of the crime and the conduct. There's a punishment attached to it, and it all stays on the record. And the good news about domestic battery conviction anywhere, I believe, is you're barred from possessing or owning any firearms for the extent of your existence. So that's something that's positive, because if you're found with a
You say for
firearm,
life?
yeah,
Yes. Oh, no.
yeah. If you're found with a firearm, that's a felony offense. Even if your domestic battery was a misdemeanor, it's a felony for you to possess a firearm.
Can you get domestic violence charges sealed if they're?
People try to get them sealed. I don't agree with them being sealed. They have to ask for permission from the court. And where it's an enhanceable offense, you can't get it sealed prior to that time expiring, like in Nevada, the 7-year thing. I don't believe you can get it sealed prior to the expiration of the 7-year period of time. And what I've been told by certain judges is that even if your domestic battery conviction is, for example, sealed, that does not affect or restore your rights to bear and possess or own firearms. So hopefully that would, but the problem is doing, making sure whatever agency knows that even if, because when something's sealed, it's wiped off your record, so there's no arrest record of it. So some cop somewhere who pulls a guy over and he has a handgun sitting in his lap needs to be able to find out somewhere if this guy is legally in possession of a gun or not. And it's just been a little bit of a problem in our jurisdiction with getting that information to law enforcement after someone's record's sealed.
Why would somebody get a record sealed? They just have to ask for it, or?
They have to petition the court. They have to prove certain things, like they haven't been in trouble within a certain amount of time since their
I see.
arrest,
Okay.
and that they've been exemplary except for minor traffic violations,
Wow.
stuff like that.
Huh.
But there's certain crimes you can never get sealed, like crimes against kids, sex crimes,
Sure,
stuff
right?
like
Like, I
that.
would think
I
that would be
was
so
gonna say, I really
dangerous.
hope
Yeah.
that's not so.
Those
Yeah.
people are like, ugh.
Yeah.
Is the punishment usually a combination of both time and a financial fine or penalty, or?
Yeah, there's a fine, but usually the fine, I'm not caring about a fine. I'd much rather have tangible punishment that's a realistic. I think fines are more appropriate for maybe certain minor drug offenses. Sometimes a fine can be effective, but only if the person has the ability to pay it. If they can't pay it, it doesn't mean anything. And so they end up doing community service anyway.
How do you guys report, I don't know how to word this, but essentially to ensure someone cannot own a firearm once they have those charges against them, what channels does it have to be put through so that they don't pass those background checks?
It goes into a CLET system, which it's called CLETs, and it's all your convictions, and it's federal. And so all the states can get it. So if there's somebody convicted in Ohio, when I pull their record, I get that they were
Okay.
convicted there.
And it has to go into the state repository first.
Okay.
So I've been told there's a backlog of thousands of cases.
Oh my.
That was my
haven't even
question.
got there. It's the Nevada State Repository in Carson. And it has to go through that system first. And then that's what the federal system taps into to get the dispositions.
So
And
if they don't have it, then those people
Don't
can
have
still
it?
have
How
firearms.
fast the backlog, is it years or months?
I would say at least.
People were saying it was like 30% of people are not getting reported, and that's why they're passing.
I don't know
background
if the
checks.
percentages, I just know there's a substantial backlog. I don't know if you put people on it constantly, how long it would take to clear up, but it's been an issue for a little bit.
So that there's not enough budget to pay for the.
Probably not.
issue people?
Yeah, I
Hmm,
don't know.
There's some gun.
I got a call, or I got an
Allocation
email yesterday from the repository having a question about a 2013 case
Mhm.
that they're entering right now.
Oh.
That was kind of scary.
Wow. Was California the same?
I don't know for sure, but I would imagine. I believe it's up to our courts to put it in
Mhm,
there,
mhm.
and I don't know who's in charge of that. I just kind of hope that it all gets done.
Yeah, and frankly, if you ask me who's responsible for getting the disposition of a case to the repository, I'd say I don't know.
Yeah, we
That's
don't do
scary.
it.
Yeah,
I mean,
yeah.
I don't have access to the system.
Yeah, but I don't know, and I don't know if
Whereas you
our
could
office
just be
does.
like,
Our office
"Yeah,
sends the
please."
agency supposedly, in perfect world, a disposition, and then the agency advises the repository, but
Secret.
I don't know if the court does something, but judgments of conviction go to the Nevada State Department of Correction, and the felony dispositions seem to get entered a lot quicker.
Do you guys think that's a problem?
I was gonna say, that's a really big one.
I
It's a
do.
problem, but I don't even know how to address it.
But it's
It's just, it's bureaucracy and just
Yeah.
throwing enough money at the problem to fix it.
Seems like it would
funding
stop
towards it.
a decent amount of problems.
Nevada Depository?
Repository.
Repository.
Yeah.
So, like, with gun stuff going on and people like mad at different things, this is something I didn't know. It's like, well, you know.
Mental
what's
health.
Yeah.
If you're adjudicated incompetent or committed under a mental health theory, not even a criminal conviction, you're not allowed to carry a firearm for this one in Nevada. And that's supposed to be by law.
Is that on the same
The
backlog?
repository is supposed, yes, yes, and there's a statute on that.
Right.
Yeah, all these requirements are covered by statute. So there's a law that says you have to do this, it's just a matter of
Get it done.
what, yeah.
So when people are saying this isn't working, like, well, we've done our part.
Mhm. We got the conviction, now you put it in the system so it
That's
doesn't
part of
go
the issue.
to Montana or somewhere and buy a gun at a,
Mm-hmm.
you know. But also in Nevada, yeah, the gun shows
Mm-hmm.
that you can go there and buy a gun and there aren't the,
They're not running your names.
yeah.
Yeah.
There's not the loophole, there's the gun show loophole.
Yeah.
Well, yeah, and they all pretend it doesn't exist.
I can tell you.
How many guns aren't really bought
That's
through
why
that.
I'm like, I'll just go to Nevada and say, can I buy a gun and see what they tell me? And I'm like, see, you don't know.
Well, it's totally scary. When we lived in Utah, if you do a private gun sale, you could have all sorts of crap on your record, and you're like,
Craigslist.
can I buy
Yeah.
it? And then I can just
A
get
lot of
it, and
western
then
states are that way, yes.
messed up.
Yeah, sometimes it's like you can sell up to four firearms, you can go over 4, but being a private dealer, it's like all bets are off.
Yeah, and ATF monitors a license of gun dealers, and they're under pretty strict rules, but like the private guys, you don't know what they're doing. And like at the gun shows, I mean, I don't know what regulations they have even, if at all.
Well, speaking of that, and do you have, like, in the profile of the cases you have, do the defendants, are they generally armed? I mean, do weapons often come to play in the case, you know? Have they threatened their spouse, with weapons? I mean,
I've had, we just had a murder down in El Dorado where the man shot his girlfriend. Right? Did you hear about that?
Yeah.
Yeah. And we have people with guns. I wouldn't say over 50%, but we've got enough that I could count probably 10 off the top of my head where guns were involved. And California just passed something where every time we have a felony conviction or certain misdemeanor convictions that they need to say whether or not they have guns or whether or not they have registered guns, and then they send it through the system to see if they're registered, and if they're registered then they need to get rid of them. The problem is that if they're not registered and they don't say I have a gun, then, and these guns aren't registered.
It's like the honor
Who's
system.
gonna say
Right.
yes? Who's gonna be like, yes, I have a gun, I'll take it.
Yeah, no.
Right, so it's getting some of the guns away, but it's not getting a lot of the guns away.
Yeah, and they aren't, in my experience, the gun may not be a big player in the actual domestic that I'm prosecuting, but the fact that the woman knows that he has guns or access to guns, and it leads to her level of fear. And if something happened where he couldn't have his guns, oh my God, he's gonna go crazy on me, and stuff like that. But the judges tell them in justice court, they have them sign an affidavit, which is new, just started recently, where they're declaring under oath that they don't have firearms, or if they do, they're disposing them, and then they're on probation, and so the probation officer gets to search your house for any guns and seize them.
Is that on
I
backlog?
like that process.
Sorry.
That process
Is that on
sounds
backlog
helpful,
too?
like being able to go
No,
to their
no,
place and search for
the
that.
probation officers are pretty good, yeah.
And then you have a question?
Those
Oh, got it.
how long do you see, after somebody's released, that they're put on probation? How long is that period, Jen?
In Nevada, it's a maximum of 5 years.
Same in California?
Same.
And they usually get cut loose before that.
For good behavior.
Or just cause.
After you create a petition.
Yeah.
Well, 'cause
Or their
I
PO
felt
can even
like-
ask for them to get off.
Yeah.
But probation is good because they have certain limitations, correct? And if they mess up, you can
Yeah, usually,
preponderance, right?
yeah.
It's very easy to violate them.
Yeah.
When they violate.
Yeah.
And they test for drugs, and they can get in all sorts of trouble.
Look at their phone, a search warrant, yeah.
I have a question on that. Is there anything on healing the person who is the perpetrator? So is there anywhere, like if you're on probation, that you have to go and get some mental help? Or?
Absolutely, and domestic violence is a 52-week program.
Oh, wow.
And if they've got
Yeah.
substance abuse issues, they can be they could be told that they need to go to residential or outpatient or AAs or self-helps, you know, whatever their problems are. It's actually a really good resource for somebody who wants to work on themselves and stay out of the system.
What's the percentage that generally have alcohol or drug issues?
More than half.
Yeah. It's a state-run program, county program, the 52
County,
program?
it's a state mandated program, but it's run by the county.
Can they get off of that if they can't afford to go to it?
No, there's a sliding scale.
Oh,
So
okay. And where's that at for Placer County?
For Placer County,
Down the hill?
it's down the hill.
Oh, so you get there.
Right, getting there, and we are actually getting a program up. We're in the process of getting a program up
Nice.
here. So
What's it called? What's
usually it's through CORE, and I'm not sure what CORE stands for, but it's
Batter
the
treatment?
52. It's the 52
Yeah.
batters program.
I know on restraining orders you can ask for it, for them to
For them
attend.
to do that.
Yeah.
Yeah. So and they need to do it, and if they don't complete it, it's a violation of probation.
In Nevada, if you are sentenced to 52 weeks and you have Medicaid, it's free. Or it's like $10 or something.
Oh, I see.
Mm-hmm.
Yeah.
Yeah.
And they have in Reno? Batter
Same
treatment
thing,
program?
mandated by statute.
You know, every once in a while we get phone calls to our offices like, hey, do you guys have better treatment programs? And we can't offer that because of funding, right? Because we're funded just to serve victims only. But it would be nice to see if, you know, if CORE brings a thing up here that we could tell people to go there. Because if they want help, they want help, right?
Right. Yeah, I'm really looking forward to that, getting up here. It's gonna be a lot easier to do it.
Cool. All right, do you need victim cooperation to prosecute a case?
Not necessarily, especially if there's an independent witness, if we have statements, if they made a confession, just if there could be other evidence that we could use. Or if we have the victim testify at a preliminary hearing and then later decide not to cooperate, we can use that testimony.
And I would say, you know, if you guys do need victim cooperation, obviously in certain cases, I mean, advocates play a big role in that and supporting them and letting them know what the system is and just being honest with them and talking about building a relationship with the DA that's working on their case and stuff like that to kind of support that through the thing. Because, correct, it's you guys go forward whether the victim wants to or not.
Right. And we are not the victim's attorney. So if you guys reinforce that idea that we are not their attorney, so we don't do what they want or what they tell us to do or anything, and it's not our job to necessarily make them happy. It's our job to make sure justice is done, she stays safe, the guy's held, and I'm using generalizations, not all men, or not all batterers are men, but that she stays safe, that there's a consequence for the behavior. But in a serious case, if the victim, and we've had this all the time, that they just want the charges dropped and they don't get to make that decision. The batterer thinks they do. The person in jail thinks that the victim holds all the cards, and you know, we monitor those communications with people saying, just don't show up, call the DA, tell them you made a mistake, and then I'll get the exact call, you know, on my line, and we have all the jail calls recorded, so we can use that against the batterer, like Maria said, extra evidence, you know, to use without the victims.
I think what gets confusing is when people use the term like, I'm not pressing charges, or like,
Yeah.
I am pressing charges. Like, it gets
Yeah.
a lot
Yeah.
of people very confused
Yes.
with like, I have control over this. When
No,
it's
they
not.
are a witness. I tell
Right.
them it's me, it's my office pressing these charges. You are not. It's not victim versus defendant. It's state of Nevada versus defendant. And sometimes when they realize that, there's a good amount of relief
Yeah.
because they don't feel like they're responsible for what happens. And I just explain to them, look, you're a witness. You know, what happened to you, you know, is horrible, but you're not the one going forward with these charges. It's us who picked up the ball when you called the police, and we're going forward. And some defendants just refuse to accept that. They think that the victim's doing it for spite or whatever reason. It's just their mentality.
Yeah.
Is the recidivism rate for domestic violence and battery as bad as it is in the rest of the sort of penal system? I know it sounds like you beefed up the enforcement as well as the penalties, so if you've done it 2 or 3 times, then you don't have to worry about recidivism because you're not gonna get out again. But, I mean, that's one question, and just assuming that most of this is male against female, which I would assume the majority is male against female men, is there like a median or mean age that you see this most prominently?
I've seen it actually a lot. I mean, and I live in a small bubble down in Tahoe City. It's Tahoe City, Kings Beach. So I certainly cannot talk for the rest of Placer County, but I see that it's kind of young. It seems to be rather young, mostly lately. And I don't, even in high school, so I see it young. But as far as recidivism, as in the system, I don't know what it is, but I do know that by the time it gets to us, it's happened before. Like, they often don't call the first time.
Right.
It's been happening over and over in their
Right,
relationship
right.
before they get the police involved.
Right. And any, like, generally, you were hearing the stories or the testimony, like, how long have the couples been together? I mean, do you have, is it all over the place, or you see it's been,
Yeah.
I mean, like,
Yeah.
you see couples that have been
Well, we
together for 10 or 15 years?
You seen that?
Really?
Yeah. Seen, yeah, most of them are new with certain kinds of stressors on the relationship, either kids,
Finances?
mutual drug use, finances, living in weekly apartments, you know, just eking out existence and, you know, infidelities, and jealousies and stuff like that. But a lot of them are young.
It seems to be a lot of
Seem to be a lot of younger offenders.
Okay, kind of switching the talk over to sexual assault. What are the challenges in prosecuting a sexual assault case versus a domestic violence case versus other violent crimes?
There's a lot of similarities if the sexual assault victim is also in a relationship, so it's a domestic sexual assault, very same. We rarely get the stranger
That's what law
rapes.
enforcement was saying yesterday.
Yeah, it's very rare. So usually there is a relationship. I think the trend, from what I can tell, and again, I have a small portion of the population. People are reporting it sooner, which is very helpful.
Sure.
Maybe it's gotten out there, or maybe people are more comfortable reporting. Back 20 years ago, I had a lot of late reports, but now they're on it and been cooperative. I think alcohol is an issue when that has become an issue in the case, and as well as social media postings, texting, that kind of thing. If they've been doing, just with everything being recorded and electronic, that's made kind of a difference and can be.
Yeah, so how does that go when like Snapchat and stuff like that is brought into place for sexual assault cases? Like you have to how do you get your hands on that kind of stuff?
We can get into phones through warrants now in California, and sometimes it can be really helpful, and sometimes not. So I mean, it just really depends on the case, but yeah, social media definitely does play a role. And you know, I'm on Facebook as soon as I get a defendant, I'm
sure.
So
I'm sure their Facebook can tell a lot. I was
Yes.
talking to the officers yesterday about, you know, if somebody has a restraining order and says no guns and they post a picture with guns, you know, it's like you're just selling yourself out. And they always do it.
oh yeah,
It's like
They can't
clockwork.
help it. They-
and it's public. I mean, I'm looking at it.
Yeah.
How do you feel about the different pressures or challenges in prosecuting?
Yeah, I would
sexual assault?
agree that with everything Maria said, part of the challenge is overcoming a presumption, and this jumps into common defenses of consent. You know, with alcohol, you know, the texting or, you know, what have you, that, you know, last thing I know, I'm waking up in this dude's bed and my clothes are off, you know, and stuff like that. And so there's kind of sometimes there's a lack of history of what happened, and, you know, sometimes other witnesses may not be very willing to come forward because they feel guilty about what happened, or, you know, they're just say, oh, she was all over him all night, or, you know, some of those challenges, but, that's always difficult, you know, because young people, and I don't know how old are you guys? Look like a range of ages to me. I didn't, so I don't want to insult anyone, but, you know, like people newly in college, you know, that leaving home for the first time, newly in college, you know, like 19, whatever, and can't really handle their alcohol and end up getting in bad position, you know, circumstances, and then they feel like part of it's their fault, which isn't necessarily true. So it has all those difficulties, and you know, sex assault, a conviction in Nevada is 10 to life, assuming the victim is over 16 years old. And that's
Over.
mandatory prison, yeah. Under, it gets into the 35 range.
35 to life.
Yeah, if they're under 14.
So is that why you need to have the absolute facts? and evidence?
Well, it helps because if someone's a rapist, you want to make sure they're punished.
Mhm.
And that, you know, that's part of the difficulty is making sure, okay, was this rape? Can we prove it beyond a reasonable doubt? Because maybe the perp is 19 too. But if he, you know, if he's a sexual predator, then he's a sexual predator, no matter what. So,
Although that's not in all states, like the swimming guy that got off, you know, that was on.
Stanford.
Yeah,
Rock.
yeah, Rock, yeah, that
Yeah, so
guy.
what about the convictions in California for sexual?
So now it's
You
mandatory.
just
Okay.
changed it because of
Yeah,
it, right?
because,
Yeah.
but it's only an 8-year max.
Right, you're getting in Nevada. We're going to
It's crazy the
California, honey.
difference.
man, just 8? Just flat?
As low as 3.
Wow. Yeah, Nevada, it's minimum 10.
Minimum 10.
Maximum life. I mean, there's no range. I mean, that's the sentence, 10 to life, period.
Oh,
Interesting.
what gets life?
Hmm?
What gets life?
Murder,
Oh, okay.
fixed life, there's murder, first degree, stuff
What
like
is
that.
it?
Like murder, rape? Like for sexual
Murder.
assault, what gets life?
A fixed life?
Yeah.
If there's sex assault with substantial bodily harm, something like that. I don't think.
It's like aggravated.
Yeah.
Obviously, if it involves children.
Children
Yeah.
issues.
So they get put in a different place in jail if you're a children rapist.
Mhm.
I don't think they have a treatment on
Yeah.
jail.
You get put in what's called administrative segregation. You wear a red suit.
Oh, you get labeled.
Stick out like a sore thumb.
Everybody
like that.
knows.
Nice.
We call them chomos.
Is that in the county and the prisons, or just in?
That's in the county prison. They have their own thing. I don't know how they dress in prison, but in the county jail, they're kept separate because they have to for liability because the other guys beat them up.
Yeah, that's what I thought.
I see.
Is that hard to prove the child rapes? Or?
Depends on the case.
Yeah.
Just depends on the case. Yeah.
No, in California, it is low at only 8, but each penetration counts as a separate rape count. So if he rapes her in one place,
Yes,
stops,
same.
starts again, that's 2, and they can be consecutive. So you can build it up. Yeah.
And if
so
it's happened over years at a time,
Oh yeah, and then it
yeah,
just
then it just
right.
racks.
But
on
I
top
mean, it
of
could
each
be just
Oh, wow.
in 10 minutes.
But that's adult. That's not child
No,
molestation.
that's adult.
Yeah.
I'm talking adult rape. Yeah, no, child molesting is much. I mean, you can get 25.
Right,
I mean, it's
right.
it's huge. But I'm just adult rape. So within 5 minutes, if he
Oh,
stops
wow.
and starts again, it's a whole other count.
Has a drink.
That's crazy.
Has a smoke.
Yeah. So that's which is probably hard for the victim because they need to be very detailed in
Sure.
their
Ah,
their
so that's a
interview,
good
and
question
so-
to ask. How many times? were you
Right, so-
penetrated?
and she's
Yeah.
like, he
But
raped me,
doesn't
come on.
But
But
it
it's-
count by orifice too?
Yes.
Ah.
When they
So-
do like the SART exam, can they tell based on like it's been multiple, like because the DNA evidence left in the sperm, that they could tell that this is not just once, but it was like 4 times in one night or something like that? Were they able to get down to that level of science to?
I don't know. I don't think so. I mean, I mean, depending on where you find the semen, you could obviously have more than one count, but I don't think so.
They can, I've said on start review teams, and they can like tell if it's, once the swabs come back, if it was two different people, but
Right.
time,
That's what-
time stamp on it, I could see like if it was in the mouth or somewhere else, you know, that could tell that it went through two different orifices,
Right,
but I don't
right.
think time stamp can
But
be.
if
Right.
they don't ejaculate, then can they still find that out in his mouth?
I mean, there's like, they can find like saliva swabs and everything like that.
Well, they swab him too, so
Yeah.
if it's mouth, and if he has her epithelial from
Oh,
mouth on him.
Yeah.
Unless he's showered, right?
Yeah,
Yeah, the stuff that they can find on your body is crazy. If you get there in the right amount of time.
assuming it's all preserved,
Yeah, assuming that it all stayed on you and it's fine.
But that,
Yeah.
it sounds like from what the officer said last night, it's pretty critical if you want to have a strong case for the DA, that you really have to have as much objective data as possible.
Yep.
I mean, do you ever end up having, you know, women that are willing to still, even without that information, willing to pursue
Mhm.
prosecution? And
Yeah, unfortunately, you have the victim who really wants, I want this guy to fry, blah, 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 but there's just not enough to go forward sometimes, and that's when you bring them in and sit them down and tell them that, explain to them, we're not your attorney, we don't file charges on your behalf, we file them on behalf of the county, and, here's what we need, and, there may be something else to explore, but.
And I had a rape conviction where she reported about a year later.
Wow.
But that's because in California we're allowed to do this, in Nevada they're not. They did a pretext phone call. She called him and talked to him about it, and he admitted it. And then when we went to trial, he said, well, I misunderstood what she was saying. I meant the time I beat her before. But she was a great credible witness. How she came to report it was totally credible. So yeah, I had no physical evidence. I just had her word and the pretext phone call.
Are the attitudes in both these places in terms of the rape, sexual assault versus domestic violence is similar in terms of the jury's general attitude and perceptions about it, similar to that, as you said earlier? I mean, is there more?
I would say probably because a lot of the sex assault, there's the relationship already, and if there's sex assault, there's already been domestic violence. So it's like
They go hand in hand.
very, yeah.
Okay, so we talked about that. We talked about the convictions. What are common defenses in sexual assault cases?
Consent.
Yeah.
It's hard to do, it wasn't me if there's DNA, and if people put them together, but generally I'd say consent.
What if consent changes? I think I was reading on Facebook some law about some other state, if you're having sex and then you're like, no, stop, tough luck. It was one state I read something.
Oh, no, in California, that would be rape. It would be
Okay,
really hard
what'd
to
you say,
prove.
like,
I mean,
yeah.
Yeah, I think that, I don't think that you're barred from ever changing your mind as a female, or any victim for that matter, any male or female, so I hope that's not the case.
Are you
I mean,
seeing-
yeah, I agree, it'd be very difficult to prove,
Yes.
but I hope that's not the case.
Are you seeing more cases being filed now? More women coming forward in light of what's going on culturally in the last several years, but certainly in the last year or two, since there's so much of the misogyny and Me Too and all the rest of that? Are you starting to see more women possibly that are being more emboldened to want to go ahead and prosecute her?
what I mentioned earlier about women reporting sooner, I believe that happened before the Me Too movement. I think it was just generally society's moved forward where it's not shameful and they feel more comfortable. I don't think that I have not noticed an influx since the Me Too movement specifically.
I haven't either, but I hope that if anyone's reluctant, that they feel comfortable coming forward.
What about sexual harassment cases?
Those are generally criminal.
Oh, really?
If it reaches like a stalking or harassment type
Okay.
thing, but sexual harassment in the workplace or something like that, that's
It's
just
like
not.
civil stuff?
Yeah,
You can just sue for that?
right,
I see.
right. If there's a touching, it could be an unwanted touching, which may end up being a battery or
Yeah.
something, but.
Okay. Gotcha. And we already talked about like what happens when a case is dropped, you know, the conversations with the victims and having them. Is there anything else you want to add to that?
I don't think so. I mean, I know sometimes it's hard for officers on the field doing the tough work out there to understand, you know, why aren't they violent, you know? And sometimes, you know, it'd help if they just pick up the phone and go, why'd you do this? But a lot of times they don't. And then it just festers and gets blown out of proportion sometimes. But I'm always willing to talk to law enforcement. And when I do a no issue memorandum, which means I'm not issuing their case, I always give them my direct phone line and say, if you have any questions, give me a call. But in a big case like a sex assault or something like that, I wouldn't just do a memo. I'd bring, you know, hopefully be able to talk to the victim face to face with an advocate. Let her know what's going on.
How do you guys put it nicely without indicating that you don't think? I guess how do you talk to them without discrediting what they feel has been done to them?
I let the advocates do a lot of the talking. Because they have a way of smoothing stuff over, and I generally let them know that I believe you when you say this occurred. However, you know, to successfully prosecute the case, here's what I need. I need proof beyond a reasonable doubt, and here are some issues I see with the case, and I can't justify putting you through this process when the outcome is not what you're going to be happy with. You know, stuff like that, and talk about in general our ethical responsibilities, and remind them we're not their attorney.
And it has nothing to do with not believing
Right,
that it happened. It's just what.
Sometimes it might.
Yeah, but I never
But
say
the
that.
majority. The
That never
majority.
presented them out.
Right, exactly. The majority of time, we do believe them. And it just sucks to realize. And, you know, before we just go ahead and say, well, we're not gonna be able to issue this case, I like to staff it with other attorneys in my office to get their opinions. Have you had a similar case? What did you do? What do you think? You know, so I'm not just sitting in, you know, by myself making a putting a red X over that one and grabbing the next file.
Too hard.
Yeah.
Yeah, that one's a winner. Let's
Do you find, I meant to ask this before, the perpetrators of the domestic violence or sexual assault, including rape, is there a high prevalence of them having previous records?
Sometimes depends. Some of them may have records that don't indicate like a domestic or a sex assault. Some have drugs, alcohol, theft, you know, just a myriad of things, but not necessarily a prior similar offense.
So kind of in a similar vein, the whole discussion about how you handle cases that you don't end up taking. You said you've been both a DA and a public defender?
No, she hasn't.
You have, okay. So, I mean, and maybe I'm totally misunderstanding the whole innocent until proven guilty part, and I'm reading too much into that. But do you think it's easier to maintain someone's innocence or to prove their guilt?
It's, and just for clarity, I didn't do public defense work as a public defender in the criminal courtroom. I did appellate work.
Okay.
So, but to answer your question, just so that it's just easier for me to say public defender because it was public, and I was defending it. So, but anyway, I don't think you can proving innocence versus proving guilty.
Yeah, like maintaining innocence, because if everybody's presumed innocent, is it easier to, I guess it may be.
I would not want to be
reasonable that-
sitting. I would not want to be sitting at a defendant's table during a jury trial on a sex assault or domestic violence.
Mhm.
A lot of times juries hear the facts and they want to hold someone responsible, and that person is sitting right there.
Yeah.
And you know, most of the time, I can't say, you know, what percentage, but most of the time, the state should win a jury trial. Unless something goes wrong, or it's just one of those cases that has to go. And, you know, so hopefully the state has what it needs to secure that conviction, but I would not want to be sitting at a defendant's table, generally speaking, on a sex assault or domestic.
And the defense attorney isn't trying to maintain that they're innocent. All they're trying to do is say the prosecutor's not proved it beyond a reasonable
And
doubt.
they're under no obligation to do anything.
Right. So innocence really has nothing to do with it.
Okay.
It's whether or not, as a prosecutor, proved beyond a reasonable doubt that he did it. Now they can think, oh yeah, I think that guy did it, but the prosecutor, but maybe he didn't.
That's so frustrating.
Yeah, it's like
Yeah.
you
Who thought
probably
he
did it.
it?
Okay, that's kind of where I was
So,
getting hung up with
yes.
the whole innocence versus guilty thing.
Yeah,
type
So
of thing.
yeah.
there's,
it's not-
it's really nothing to do with innocence. They're trying to show that I've not made my case. That,
So trying to discredit you versus.
not me personally, but my
Right,
case.
right.
Yeah, yeah. That there's
And the
some
victim.
reasonable doubt.
Depending, right.
But yeah, they,
You can't believe her.
Yeah.
The cops screwed up the investigation.
If someone hires a private attorney, are they gonna hit that stuff a lot more harder on the dotting the T's and crossing the I's with the I's?
Not necessarily.
yeah. Our public defenders are very good and very experienced. They do it every day, where a lot of private attorneys don't.
And then you all know each other, right? You're like, oh, they got that guy. It's gonna be a fun day.
Yeah, yeah.
Do you ever think that it would be easier or better if it were the other way around, especially with like the victim blaming and all
No.
that kind of stuff?
No,
It
no,
would
the
not be
system,
easier
the
to
system
prove innocence?
is, works the best because it's the way it's set up. It's up to the state, the government to prove someone guilty beyond a reasonable doubt. It'd be virtually impossible to prove you're innocent of something. It's like proving a negative almost.
But it'd be awful. It'd be awful to be that person.
It'd be like
where-
Minority Report or something like
Yeah,
that.
I always
Yeah.
wondered, because I know there's some other countries that do that you're guilty until found innocent. And I'm
Yeah,
always
that-
like,
That's really scary.
Yeah, it is
You'd
terrifying.
have
Yeah.
a lot of people in jail.
yes.
Horrible. It'd be horrible.
horrible.
I'd probably move to another country. Yeah.
Do you guys feel like in these, especially sexual assault cases, how much of that victim blaming is brought to the forefront by that defense attorney?
It just
Is that
depends
just like,
on what's out there. Depends on, we file motions to try and prevent some of it. There's rape shield laws that we can use to get the defense not to talk about prior partners and stuff like that. But there's only so much we can do to protect her from our own actions, essentially. And we do what we can, but if the defense has dirt on someone that goes to the credibility of what they're saying to the jury, that's gonna come in.
is it pretty textbook for them if it's like, you know, I was out, I had 2 drinks, I never passed out, and then I woke up blacked out and my panties were off? How often are the defense attorneys jumping to, well, I mean,
You were wearing a short
you were
skirt.
wearing a short skirt and
No.
that doesn't happen?
No, not, I think that the defense, that the jury would not be having any of that. But what we do have is them going to their social media and finding it where she says, I'm gonna say that you did this, whether it be a rape or whatever, I'm gonna lie about you because you didn't let me see the kids. Something like that, and now that goes to her credibility. So they'll find dirt on her, but I don't think that the juries will have any of, you're wearing a short skirt.
Yeah, and if there's photos of what the victim was wearing prior, they can tell what she was wearing. So if she's wearing a short skirt, you don't need to say it. You just let them draw their own conclusion and what's in their own mind. But this she asked for it stuff, that doesn't really play. That's not a valid defense.
It's not.
No.
Unless, but with that said, consent means that there was a mutual understanding that this activity was agreed upon by both parties. So if the woman is so intoxicated and drunk and throwing up and whatnot, there's no way that she's knowingly
Agreed.
agreeing to that sort of conduct, and the guy should know better. And that's one of the standards in Nevada. I mean, he knew or should have known that
Yeah.
this.
I
She
just
wasn't-
wonder how much the society plays into that, because society definitely puts that on women a lot.
It does.
Like, you know, you were out by yourself, you know not to drink a drink unattended. Why didn't you do this? Why didn't you do that? Why did you do this? Why did you do that? I always wondered if that played into the court cases very much. I mean, as far as between the litigation part.
Well,
so
it's
much
not
the
gonna
jury.
be the reason why someone's acquitted, in my opinion. it might be something they want to bring up,
Mhm.
you know, but in my opinion, I mean, just because a woman goes to a bar by herself doesn't mean she's consenting to have sex with
Yeah,
everyone
oh
in the
yeah.
bar. So, and most people understand that. And if some people snuck on the jury that didn't, then that's our bad for not catching them.
Yeah.
You know, do you have much pushback in terms of the whole defense of like trying to prove the promiscuity of the woman or the man?
That's
or
a
the
rape
woman?
shield, that would be a rape shield thing, where there's a statute which would provide that the defense can't get into that. Because if you consent with John, that doesn't mean you automatically consent with Joe. So you can choose to have activities with John, but you're not choosing to with Joe, and the fact that you consented with John, what does that have to do with anything?
So they can't like bring up Nevada specifically, like a sex worker. They can't bring up her career as a reason why that's not rape. She's a sex
Well,
worker.
I think that would come in under the circumstances of why these two were together in the first place. That would probably come in. If it's the boyfriend of the sex worker, then absolutely not, that shouldn't come in.
Mhm.
Because that has nothing to do with the, you know, monetary exchange or whatever it is.
Is that hard to prove to sex workers? Because there's a fine line on that, or is
I
it-
haven't had a trial with a sex worker as a victim. Yeah. I'm not sure how many, to be honest, would be reporting
That's
sex
kind of what I
assault.
was wondering. I mean, because if they're
Especially if they're reported, if they're raped by their pimp or someone like that. I don't know that they'd be willing to report it or cooperate, and then they disappear sometimes.
Yeah.
It might be under the understanding that like I'm already committing a crime, and then like, you know, this happened to me while I was already committing a crime.
But there's certain protections
There.
for those folks. I mean, the officers understand that, hey, what do we want to do? Punish the guy for rape or give this girl a citation for walking the
Yeah.
streets? I mean, they, you know.
Yeah, but I mean, like if you're like if they're a sex worker at the Bunny Ranch, like a legal on the up and up, and she's out at a bar with a friend, date rape thing, could they bring that up in court and say, well, I mean, she's a prostitute, so how much is her word really worth?
That would, the prosecutor would file a motion to prevent that exact argument.
Okay.
And being a prostitute doesn't have anything to do with your credibility.
No, I know that.
No, I mean,
I wonder if
judges
that's
know that.
You mean
Yeah.
that
It's not.
she has sex with everybody anyway, so. why
But
not
really
this
hope
guy?
you
Yeah.
don't have judges who have that
Yeah.
mindset.
Yeah.
No, they would be judged law.
Do you see much spousal rape at all?
Not very much. Kind of rare, once in a while.
It's more fashionable.
Well, I honestly wonder how many women even know that that's a thing. To be honest.
In some cultures, here in Washoe County, we've seen some cases where the woman did not realize that she could say no to her husband. And sometimes, if they don't speak the language, they're very isolated
Mhm.
and depend on the guy for everything, pretty much. And some of them are undocumented, they're afraid
Yeah.
of shining a spotlight on, you know, that they're present, and so that's really sad. Trying to have that population trust law enforcement enough to handle the situations.
All right, the final two questions. What is the most challenging part of your job, and what is the most rewarding part of your job? Who wants to go?
I guess the most challenging part of the job is dealing with those cases where I believe that it happened, but I don't have enough to go forward on it. Though that just doesn't sit right, but it is what it is. But just accepting that is challenging. Putting that case, declining the case when I believe it did happen. The most rewarding part is when somebody who really deserved justice got it. I mean, when a rapist gets convicted and goes to prison, that's pretty rewarding.
Yeah,
I echo that sentiment and just say the most challenging is similar to what Maria said, is not being able to make a victim feel like the system worked for her, and that's difficult. Hoping that if they need to report again, that they will. And you know, frankly, we cannot make everyone happy, or should we try to, but it's kind of human nature to want to make someone feel better, reassured about the circumstance, and we just meet them after a horrible thing had happened, so it's difficult that way.
Most rewarding?
Same as Bree.
Yeah.
Justice is done. Yeah.
Justice is served, eh?
Yeah.
Well, thank you guys for coming in. Really, I really appreciate it. We appreciate it. Doing
Nice to
good
meet
work.
you.
And, yeah. Give me a call if you ever need me. All right, we're gonna take a 5-minute break and then come back and talk about victim compensation.
digging for everything. And I was in a way bigger city, so I didn't have like a top of safe. And it is unreal at how like our DA didn't show up 4 times in a row.
Oh, wow.
Yeah.
And so there was that
nuts.
busy. So it's ridiculous. It's nice to have like an Andrea around to be like, hey, what's happening?
Yeah, and you know, it's great to have them in here. It also builds relationships. Now you know who they are and you have their emails, and so if you ever have questions or somebody else has questions, they're always free to talk. Like I said, they're on board too to try to combat this as much as they can and put those people behind bars who really need to be back there, and the other ones, you know, get treatment and things like that in certain situations. It's great to hear that they're gonna have a batterers treatment program up here. I mean, that is nuts, because I can only tell you how many people are probably like, no, I'm not going to, and it never gets followed through because it's down the hill. And you know, up here, it's a pretty, judges use that as a pretty valid excuse of transportation and things like that.
Well, this is
so.
mandatory too, so
Yeah.
as part of the sentence
There's
or
no bus
whatever.
Yeah.
coming, no?
So, moving kind of on the scale or on the path next after, it could possibly be after criminal conviction or even not criminal conviction, like even if law enforcement and stuff was not involved. We're going to talk about victim of crime compensation, which is a thing both in California and in Nevada if you are a victim of a crime. And then we're also going to be talking about VINE, which is victim inmate notification enforcement, and talk how these different kind of systems are here to support victims. So I just wanted to give you a little lowdown before we start getting into how the California Victims of Crime Board has created like this little interactive thing that I'll go through instead of spelling it all out, which is kind of cool because it's really user-face friendly, although I don't know if it's in Spanish, so it may not be, or any other language. But basically, when we're talking victims of crime, oh, I forgot. So victim compensation is you're getting compensated for suffrage of what you've experienced for a crime. So a crime occurs, the victim suffers, and then you either report or you don't report, and that victim is paying for suffrage. So whether that's financial loss, loss of employment, medical bills, mental health services, things like that. Now you have to pay for it up front, is the issue. Because then, once you pay for everything, you'll submit your application, and then if it's approved or denied, if it's denied, obviously you stick with those financial burdens, but if it's approved, a victim comp will pay you directly as a victim for, and it differs a little bit up to each.
How often do they get denied versus approved?
It depends on what they're reporting, when they reported it, and what they're asking for assistance with. There's victims of crime only pays for a certain amount of stuff. And so then I have on here, Nevada pays up to $35,000. And California pays up to $70,000.
That's a huge difference.
Yes. Very huge difference.
This comes out of like a state fund?
Yeah, so we'll talk about the different funding sources that it's gonna come out of if I can use this little thing.
One trip to Tahoe Forest.
So what if they like file and they are saying, oh, I lost like 20 days worth of work, but then they continue to lose days of work, do they just continue paying?
So yes, so as long, as long as victim crime approves the time that you took off work. So let's say like you keep taking off work to go to criminal hearings and things like that. They'll keep approving that kind of
Oh, you just
stuff.
have to keep reporting.
You'll just have to let them know once you get a worker and things
Okay.
like that.
And you just have to stay really on top of it. It's
All right.
government funded, so.
So let's,
So cool. Is it violent?
I can't, this thing is nuts. Okay.
Physical injury or emotional injury.
So
as a
it's kind of
direct
bland,
result
but
a
it
violent
gives you
crime.
all the
We are a
information.
state program dedicated to providing
just do
financial
one of the links?
compensation
Yep.
for many crime-related expenses. Victims who suffer physical injury,
Does that help?
threat of physical injury, or emotional injury as a direct result of a violent crime may qualify for financial assistance.
Penalty assessments are state and local penalty assessments. So like traffic fines, speeding tickets, parking tickets, things like that. Little percentages of those go towards the fund.
See, so they should have given me the tickets so I can help pay for them.
I know, right? Come on, what are they doing?
I'm like,
So,
Now you don't mind paying for it.
on the court ordered one, are they able to like garnish wages?
Yes.
Or-
Yep. So what happens is if somebody does not make regular payments, most likely, from my understanding, that they do end up garnishing wages. It's just based off of what the prosecutor files eventually. Yeah. Kind of like child support stuff. And then obviously Victims of Crime Act, VOCA. So these are federal grant funds that come from penalties paid by offenders convicted by federal crimes. So we're talking money, usually money crimes or higher up crimes, that most of their money goes into this pot. And then we also receive money from VOCA to do our services. Okay? And
Now that you know more about our program, let's discuss the types of crimes that qualify a victim for Cal VCB benefits. Did you know that homicide,
a few crimes. Other crimes are,
In this section, you'll learn more about who is eligible for Cal VCB.
and those are people who are like victim advocates for the criminal justice system and are hired by different counties. And those are people that work with DAs and witnesses, which are usually the victims, setting them up with this kind of help, along with talking to them about the criminal justice system and being there when they testify and all that kind of stuff and what's going on with the case. Now, depending on where you're at, like our victim advocate for Nevada County, she lives down the hill, is only up here 2 days out of the week, the new one. So it's tough to fit all the cases that are going in. Reno has limited supply as well. They have lots of cases to get a hold of people. So that's good where it comes in, where like community organizations like Tahoe Safe Lines can also help out with that.
What percentage would you say of the people that you're providing services to or shelter to actually go through this process?
All the way to approval, or who submit an application? So we try to get every person. We try to get every person to submit an application, because if they approve it, they approve it, you know? And if they don't, they don't. But it's better to, you know, get it in there, get people knowing that like you have these options. Approval, it really just depends on if they documented it well. Like if they have medical records, if, you know, they base it off of documentation. You just can't go in there and say, this happened to me and I need, you know, I did this. You have to prove like loss of employment or loss of wages and things like that.
Well, let me ask you, it brings up just another question, which is how many, because obviously a lot of people that use the shelter, and I'm sure we probably covered this in some other classes, but are actually where the perpetrators have been prosecuted or currently under prosecution, and it's still waiting to go through the whole court system, and, you know, depending on the dockets and whatnot. So do they compensate even if you don't really have, you know, evidence that this person is being prosecuted, has been convicted of a crime, so they still have that then?
Yeah, so they can do it where if you didn't report at all, but if you have like medical records or like, you know, if you can prove that you had some like emotional, mental distress that made you not show up to your job for a while, right? Or, you know, from a mental health provider can write a letter, things like that. You can get recompensated that way, and medical bills. It does help when you have a report from police and things like that. But they allow you, they understand that. That doesn't have to happen.
We've covered this in the past, but for those victims that are in the shelters that decide they don't want to continue prosecuting, do you?
No.
So, you know, there's no judgment in regards to that.
Yeah.
Right, okay.
So yeah, most nowadays, I can't really speak for like way back when things used to start getting, or started up and were stricter and things like that, but I would say nowadays, the shelters that I've worked at, if somebody decides that they don't want to cooperate with prosecution, they don't want to be involved in testimony or, you know, and things like that, that's their choice, and that's what happens. We still look at them as survivors, and so we still support them in that, even if they do choose not to go that route. Now, before they choose that, we're going to try to empower them to choose that route, but I mean, when you're talking like sexual assault cases too, it's good to be honest with them, and if they choose not to, they choose not to, and they still get they don't get services denied to them at all.
Okay.
Yeah, if anything, we probably support them more with trying to find like restorative justice, where they feel that they can like move on to their next part of life without with the missing piece of the criminal, you know, justice being served, which is tough. But it happens. Yeah. And just, you know, anybody that comes into services, like, we're not asking like, prove to us your domestic violence. It's all self-disclosure, voluntary thing. So if you say that this happened to you, we're believing you. Yeah. Okay, so that's that. And then one more thing is another service that we connect victims to is it's called Vine, and it is a notification center for when inmates get out of jail. So you heard in Nevada they have a 12-hour hold, but in California it just depends on when they pay their bond. And so this is a system that keeps them safe, lets them know that their abuser is no longer into custody, and you know, knowledge is power in this situation as well. So
What's Vine stand for?
Vine stands for, my understanding, it stands for Victim Inmate Notification
Something else.
Enforcement. I think it'll tell in here.
That's a cute logo for something like
Yeah, so horrendous.
right? The perpetrator is out.
I'm trying to get people to use it more often. So this is another thing that our advocates, the second we know that one of their perpetrators was abused, we're going to sign them up for this. And this is a little demo thing it'll tell.
Across the country, crime victims and other concerned citizens are using Vine for access to timely and reliable information about criminal cases and the custody status of offenders 24 hours a day, over the telephone, through the internet, or by email. Vine, which stands for Victim Information and Notification Every Day, was created in 1994 in response to the death of Mary Byron. Mary and her family were assured that they would be notified when her attacker, a former boyfriend, was released from custody. Notification was not made, and Mary was assaulted and murdered without warning. Unfortunately, Mary's story is not unique. Vine is a system designed to help prevent cases like these. Communicating with jail and prison booking systems in near real time, Vine provides the general public with timely access to offender data. Users can register to be notified in the event of change in the offender status, such as release, transfer, or escape. When a notification is triggered, Vine automatically attempts to notify victims by calling the phone number or numbers the victim has provided, and continues calling for a designated period of time or until a confidential 4-digit PIN is entered. Victims can also choose to be notified by email, fax, letters, or TTY. Vine is free to the public and can be accessed by calling a local toll-free number or online at www.vinelink.com anytime, day or night. To date, more than 2/3 of the nation use the patented Vine system to keep victims informed about offenders' custody status. These communities are connected through the APRIS Data Network, the nation's largest integrated criminal justice sharing database. Vine provides a life-saving service to victims at no cost, saves money by eliminating the need to manually notify victims, is backed by around-the-clock support through live operators and technicians, gives peace of mind and empowerment to victims, is a proven solution for victim information and notification. Put the power of Vine to work for you.
Yeah, so that's a cool little promo thing of it. Before you would have to call up a jail or prison yourself and ask for the inmate or have an inmate number, and then they would have to search their system, which is a manual kind of thing. Sometimes it pops up, sometimes it doesn't, about the person, just based off of different databases that they have there. Sometimes you can get through to somebody at the prison, sometimes you can't. So you might have to be doing that a couple times a day to figure out if they're in or if they're not. So this is great. So they know,
How does the victim feel when they know they got out early? It's gotta be scary.
Oh, I'm sure, yeah. Yeah, it is scary, but it lets them know that they're potentially in a spot where they're unsafe now. And so they can safety plan or go into a motel, call our helpline, say, hey, I just got a notification. You kind of have a peace of mind when somebody's in custody. And before it used to be, I'd have to call all the time to see if he's still there or she's still there or things like that. And this time it literally calls you more than once until you put your PIN in. Or text messages you, or some people put our office phone on there too, so it'll call their advocate, and then their advocate can let them know just in case they don't pick up the phone. So yeah, it's a great service, and we try to have everybody who has had an abuser in custody sign up for it. For sure.
How long has that been around?
They just revamped it last year. It used to be you had to log in, submit an application to set it up, and now it's something where you can just call and set it up to your phone. I think you can text message it too. So they've definitely made a lot of improvements. It's been around since, I think it said on there 1994, but it used to be I think at first it started in mailing in and stuff like that. Yeah. All right, that's all I have for today, unless you guys have any other questions.
Thanks for coming.
What was the year again?
The what?
And it's victim information notification. What's the year?
Every day.
Every day. Every day.
It looks like we're not gonna get gnarly snow on Thursday.
That's great. That's good to know.
I'm really hoping, because SART is, I don't like the presentation because it's depressing, but it's like a really
It's a good
knowledgeable
information
one.
thing. So if we do have a snow day, I'll let you guys know. But let's hope not. And let's plan to be here. It's going to be a full class. They usually take up the full 3 hours. And then just a reminder, April 5th is our final class date. And probably by the end of this week or beginning of next week, should send out all the videos, correct?
Yeah, I mean, with spring break, I'll be caught up.
Yeah, so yeah.
And the test is the questions on the